In the early 1960s, society was becoming increasingly concerned about the sale of dangerous weapons. Parliament had recently passed the Restriction of Offensive Weapons Act 1959 to regulate the sale of flick knives. This law made it a criminal offense to sell or offer such knives to the public. Against this backdrop, Mr. James Bell, a Bristol shop owner, displayed a flick knife in his shop window with a price tag. There was no special advertisement, just a knife behind glass as you would expect in a shop. A police officer noticed the display and charged Mr. Bell under the 1959 Act, arguing that he had made an offer to sell a prohibited weapon. The case went to court, raising a critical question. Was the display of the knife in the shop window an offer, or merely an invitation to treat? The issue was whether the display of a flick knife in a shop window with a price tag constituted an offer to sell under contract law, and therefore violating the Offensive Weapons Act of 1959. Rule: in contract law, the principle is that displaying goods in a shop window or on shelves is not an offer, but an invitation to treat. An offer is a definite promise to be bound on acceptance, while an invitation to treat merely invites customers to make an offer to buy. The Restriction of Offensive Weapons Act criminalized making an offer to sell, but it did not extend to invitations to treat. Application: the court examined the meaning of offer in both contract law and the statutory context. Prosecution argued that displaying the flick knife with a price tag was essentially an offer any member of the public could accept by walking in and paying. So Mr. Bell had committed an offense. However, the defense argued that long-standing contract law principles established that goods displayed in shops or advertisements are only invitations to treat. The customer makes the offer by approaching the counter to buy, and the shopkeeper may accept or reject. Therefore, Mr. Bell had not made an offer within the meaning of the Act. The court agreed with the defense. Lord Parker C.J. held that the display was merely an invitation to treat. The Act was written in legal language, and Parliament was presumed to use words in their technical sense, since an offer in contract law did not include a shop display. Mr. Bell could not be guilty. Conclusion: the court ruled in favor of Mr. Bell. The display of the flick knife was not an offer, but an invitation to treat, so he was acquitted. This case reinforced the distinction between offers and invitations to treat, confirming that shop displays are not legally binding offers. The decision in Fisher v. Bell 1961 highlighted how precise language in law can determine guilt or innocence. Though Parliament later amended laws to close this loophole, the case remains a cornerstone in understanding the foundations of contract law for law students. It illustrates why knowing the difference between an offer and an invitation to treat is so essential. If you found this breakdown of Fisher v. Bell 1961 helpful, make sure to like this video, subscribe to the channel, and hit the notification bell so you never miss a case explanation. Comment below with the next case you want explained, and I will cover it for you.